I could not hear you. I saw you.
Sorry. We are now live.
Okay, great. Well, thank you very much. Well, good morning, everyone. Thank you all for being here. It's great to see your faces. This is a little bit of a different way of doing business, I know, for many of us. And I must admit, I'm I'm still getting used to it myself. But I'm so glad that we have this opportunity. So it's a little more difficult, probably, maybe to do it this way than doing it in person, but I'm sure we'll get through it all today. And as I say, I thank you very much for being here and participating. Before we get fully started, I just want to say what a fantastic job Jen Botts and Heather Marchioni have done in putting this together. They've done, as I think I described before, a stellar job in pulling this all together. It's not an easy thing to do, and there's a lot of issues that we're working on. So I just really want to say thank you so much to both of you for all the work that you've done and all through this whole process, and more to come as well. Just reminding everybody, we are in the final stages. We're working on getting this report done with general recommendations. And just to point out, we are not drafting the legislation. That comes after this. I think everybody probably knows that already, but I just want to make that clear. We're not drafting legislation. That'll be done at the request of the senators and the delegates to legislative services as part of that whole process, as I understand it. We're also really limiting this to the work that we've been tasked with doing. We've talked about a lot of different things in our deliberations, some of which were actually outside perhaps the range of what we've been tasked to do. So we are going to be concentrating specifically on that. I would also point out with the COVID-19, obviously what we're seeing is a lot more bad things that are occurring. There is, I'm told, a lot more domestic violence cases. There's a lot more of child endangerment cases that we've been dealing with. So this really becomes even more important as we've been experiencing through the COVID-19 times. And just again to remind, I don't have to remind you because you all are advocates of this, but we're here for the children. That's what it's about. And so it's as I say, become even more important for them that we get it right. And the end goal, as I understand, for finalizing our report is September 1st through the 15th. And we will have one more meeting on July 28th. We have scheduled. I'd like to get through as much as possible today with the recommendations, but to those that we don't get to today, we will finish up on the 28th. There also, I'd like, if we finish a recommendation, I want to put it to bed. I don't want to have to go back and rehash all of this again. So to the extent that we can get all that done today, as much as possible, that would be really terrific. So that's sort of my opening comments. Again, thank you all for your wonderful participation in this. And I think the next item on the agenda that we have is the approval of the minutes of January 28th. And so I'd like a motion to accept the minutes.
So move.
Is there a second?
A second.
Okay. Are there any discussions? Does anyone have any corrections or additions to the minutes as you've read them? I think everybody got those ahead of time. But are there any additions or corrections to it? Okay, seeing none, then all those in favor say aye, please.
Aye.
Aye.
Okay, any no's? All right, so that passes. And so now we will we'll go into discussion of the draft recommendations. Unless anyone has any other comments that they want to make at this time. If not, we'll get directly into going over those individual recommendations. Okay, presumably everybody has those available. Is there anyone that doesn't have those? Okay, if you don't, please let us know. So we'll start off with draft recommendation. Oh, great, thank you. Even better, they're right in front of us on the screen. So draft recommendation 1. Are there any discussion regarding that? Please do so now.
I hope that we can proceed forward with this bill again. This is Senator Lee. I introduced it and worked with Mary Beth, and we had worked with the House side too. There just was not enough time, I think, to get this bill out. But I would recommend that we move forward on this recommendation.
I'm sorry. Could you say that one more time, Senator Lee?
Oh, certainly. I'm sorry. Yeah, this was our bill in the Senate, and I think because time ran out because of the pandemic, we weren't really able to deal with this bill. But I would recommend that we move forward on this bill again in the next 2021 session, because I think it's a good bill, and it gives the judges the ability to explain why they're doing their particular decision.
And the family law section didn't oppose it if we took out the with neutral and physically present supervision. So I know this group would prefer that in there, but just keep in mind that the family law section of the Maryland State Bar Association, they, I think, were neutral, if not supporting, but they wanted that out.
So Michael's right. This is Lori. When I'm trying to refresh my own recollection, which I'm having trouble doing, but the sense of people that we talk to who practice law is that the physically present supervision was not necessary or viable in terms of just logistical options for people a lot of the time. And so it wouldn't provide a sort of fact-based choice to do something a little bit differently in case-by-case ways. And I think that's why the family law section was not, didn't particularly like that language. And I thought, Michael, that we had alternative language as an amendment that we were going to propose if we were able to get that far. Is that am I right about that?
The language we had drafted, I think, was just to take that out, and they were
just
okay.
Take it out. I just don't have it in front of me.
But if that, I think that's why it would be good to just discuss it. If there's maybe a different way to phrase it, like maybe you'd have to articulate why there's no supervision, maybe something along those lines, like just another articulation requirement. If there's not supervised visitation, explain why. What are the circumstances?
Can I jump in for a second?
Of course.
So I think that one of the things that happens all the time is that the different types of abuse all get lumped in under the broad banner of child abuse and neglect. I think it's probably appropriate to have maybe even a family member in a neglect case be able to supervise a visitation, but certainly not in a child sexual abuse case. So I'm aware of a lot of cases where you had parents of the offender that were approved as the supervisors, and then they, of course, don't believe that their son committed the abuse, so they leave the child alone, and then the child gets re-abused. So if there's a way for us to put in some language here that would specify under what types of particular child abuse and neglect findings or orders neutrality and physically present should be mandatory, and where other cases where there's some room for other solutions. Maybe that would be a little bit more amenable to the Family Law Committee.
I take your point, Camille, and I agree with you that sometimes we see supervision ordered by a court that's not solving the problem or even protecting the child in any way. But in a way, if you don't specify, and I don't think I have a position on that. If there was language that sounded good, I think I'd agree with you. I'm not sure what it would say. But if things are less specific in the statute, you both give judges more room to make the right decision and the wrong decision. So the articulation of the finding could solve some of what you're saying. In other words, I'm just trying to think hypothetically, if father's father came in and testified, I don't believe my son is a child abuser and I don't believe he did it. It would be hard for the judge in articulating his finding that he found that abuse occurred, but he's going to let dad, grandfather be the supervisor. It doesn't really work once the judge has found that child abuse has occurred by this person. So some of it could take care of itself in the art stating the reasons for the finding. I'm just trying to think this through. I totally agree with you. Anyway, that's just my view.
Was the opposition both neutral and physically present? Because neutral is the operative important word there, in my opinion, for the reasons Camille said. I mean, was the opposition to both? Because some way that we're signaling.
That's my question too.
It can't be a biased supervisor and all the reasons that we have seen and experienced. Is that? But
the bias goes both ways. So in a protective order that's intimate partner violence, I want my mother to supervise the father of my child, and she's not neutral either because she dislikes him as much as I do or whatever the situation is. So you're right that neutral supposes that, but I think realistically there's not always a neutral party available to the people, and the factual circumstances don't allow for them to use the supervised visitation center in any viable way because of work schedules or whatever. And the limitations on these supervised visitation centers are so huge. It's got to be Friday night between 5 and 6 for, transfer of child, or only on, X day for 2 hours. And if dad's a truck driver and is not in town on those days, supervised visitation centers don't work. So you don't want to back the court into a total corner, but you have to balance that against protecting the child. I get that, but.
Right, but are they opposed to physically present? I mean, I don't see how anyone could possibly supervise somebody if they aren't physically present.
I think that's a fair question, and I think the family law bar would have an answer to that. But yes, I think they are opposed to physically present.
Really? Now,
I just can't recall exactly why.
And now, having said that, I've never experienced a case in 20 years where a judge ordered someone not physically present. So
right.
I'm not so sure it's a problem that needs a fix. And I suspect their opposition is much more towards neutral for the reasons you stated. I always oppose when I'm in court having a family member do it on either side because of the conflicts of interest and everything. But the reality is, as you point out, Lori, sometimes there's just no option. And
right.
the judge is not going to agree not to allow
right.
a parent to have supervised visitation.
Exactly. I mean, they won't say, well, we can't find a neutral person, so we're just going to not let
There's
the
no
abusive
money.
parent to have visitation.
Right.
They don't do that.
Right.
The parents get the visitation anyway.
Right.
So then they say, you all go come up with somebody, and you go back in the courtroom with mom or sister or somebody, and they're naturally biased in one, often in one direction or the other.
May I make a suggestion?
Sure.
What about if we change the language to say, except that the court, I'm reading it from the draft recommendation, except that the court may approve a supervised visitation arrangement and a supervisor that assures the safety and the physiological, psychological, and emotional well-being of the child. That way, the court has to ensure that the arrangement provides for the safety of the child and the supervisor provides for the safety of the child. Implicit in that is that it has to be somebody who's not going to allow further abuse to occur. So, the grandparent who doesn't think that that their son sexually abused the child would obviously not fall under the type of supervisor that the state requires.
And I mean, you often do get agreement between the parties that, his mom is a good supervisor. I'm fine with that. So you don't want to say, and she's probably biased in some way, but the parties still agree to let her. So if you, I mean, that's not a bad middle ground, I don't think.
Maybe make it plural, because there are probably a lot of people that would be in that role.
Right.
Right, and a supervisor or supervisors.
Can you repeat that language again, Nina?
I'll try.
Yeah.
I'm less comfortable with that language because we're still not breaking it out by type of abuse. I really think we need to break out by type of abuse.
I'd agree with Camille on that. I wanted to say that I think that's throughout the document, throughout our recommendations, we don't break down neglect from child abuse, from child physical abuse. Emotional abuse is not even added in at all. And, you know, that can be just as destructive as in domestic violence case. It's a way of controlling that's not healthy or safe for kids. So I really do think that we need to break down the types of abuse and neglect for the whole document, not just this section.
So the language that I suggested was the court may approve a supervised visitation arrangement and supervisor that assures the safety and the physiological, psychological, and emotional well-being of the child. So
Right, yeah, that doesn't
and
get us.
supervisor.
Yeah, that doesn't get us where we need to be on child sexual abuse, I don't think.
Well, it is broad, so it would have to, you know, depending on the circumstances, the court has to make arrangements. I mean, you're not going to have overnight visits in the home of the abuser if the grandparents live with the abuser. So that's
Sure you do.
the situation. But what
Yeah,
I'm saying
absolutely
is
you
that-
do. Absolutely you do. Yeah.
I know, but what I'm saying is with this language, that would be an abuse of discretion because it wouldn't provide for the safety of the child.
It's not how the judges come down on it. It's just not how they come down on it. They really believe it's okay. Like it's just, that's too overly broad for child sexual abuse specifically. It's overly broad.
Well, I just don't know how we can make this statute address every single specific situation while still giving the courts some discretion to make things either more stringent or less stringent, depending on the situation.
Okay, you break it out by child sexual abuse. I think that child sexual abuse has to be its own separate, it has to be dealt with in a different way. For decades, we've been lumping it into this broad umbrella of child abuse and neglect, but child sexual offenders specifically are very different than your child physical abuse or your child neglect. The issues are very different. The type of offender is very different. So absolutely, you have to break it out. You cannot put it under, we have to stop putting it under one umbrella. It's not the same type of offender at all.
Agreed.
Thank
So
you.
folks, let me interject for a minute. Again, we're not writing the legislation today. That's something that legislative services and the senators and delegates will be doing. This is all great input on all sides on this. And so that needs to be captured, obviously. And I think that Jen can perhaps add that in. Jen, if you could take a look at that, perhaps. But again, we're not writing the legislation today in our recommendation. This is great, what we have. It's a really good statement that's been put here. But that won't be necessarily the final legislation. It may be, but not necessarily. So what we're doing is we're trying to give some legs to the rationale for what we're trying to do. And so, as I say, we're not gonna wordsmith, I don't think, today on the legislation. But as sure as long as we get it, make clear the concerns that we have, and there's very specific things that Camille was just raising as well, and Claudia, are key points that we have been discussing now for a year, I guess. I think if we capture that as part of this, as part of our recommendations, that these areas, this part of it needs to really be looked at very hard, and we've got to come up with some solutions in the legislation itself that addresses that. Jen, is that helpful?
Yes, sir. I would say maybe take one of two approaches. We could either sort of table it and just continue to see how far we keep going, and we could propose something a little more specific at the next meeting with some input from people, or we could just change the recommendation. Instead of saying make the following changes in statute, do something a little broader. Really up to you and the members I don't want the recommendation to say make the following changes in statute if we're not actually going to make those specific changes.
I think that Michael and I can work with, those that are concerned about this, and work with Jen to perhaps come up with something with some proposed language, since we are going to be doing the bill. But we'll work with you. We'll get everybody's input.
Well, that's great. That's a good suggestion. So why don't we do that, and we'll bring that back again on the 25th.
Okay.
All right, let's go to the next recommendation, number 2 then. Okay, I think, can you see it on your screen, or if you have it in front of you? Comments on draft recommendation 2?
Yes, I think this is an excellent idea. I think Lori and I discussed this earlier, how there needs to be a different definition of domestic violence that's separate from the abuse provisions that cover protective orders. And in custody cases, it needs to be much more expansive to include behavior that wouldn't be considered worthy of protective order, but certainly should be considered when determining custody, like coercive control.
Okay, great, Paul. Anyone else like to raise any questions or comments, or
Maybe
opposite,
just
if
also
anybody
throw in there to clarify, because I know right now with the current situation with the court, some DV issues are going in front of commissioners. But you don't want to go in front of a commissioner if you have a family law issue. And if you don't have custody of your kids, you're not going to be able to take them to the commissioner to provide evidence. So maybe just making sure this is jurisdictionally clearly in the circuit court too.
Okay.
But Michael, I'm not
comments?
sure it works that way, in the sense that if you go for a protective order in district court, we want those judges to determine custody in the context of a protective order. And I get that with the commissioner right now, they're just issuing the IPO, and that's going to change on July 20th. The courts are opening back up for temporary protective orders. So while I understand the point you're trying to make, I think procedurally you're not right in a sense, because we have fought to get district court judges to do what they're supposed to do in a protective order, which is to address custody. So it's not just circuit court, it's any
I might have
protective
misspoke.
order.
I meant
Yeah.
to make sure they can go to circuit court, not excluding district.
Okay. I agree with Paul's articulation that we don't want the definition of domestic violence to only be what the protective order lays out in the statute. That's not sufficient for really determining what's in the best interest of the child. So whatever it would look like, I just don't want you to,
No.
I didn't want people to be mistaken that it only happens in circuit court, because that's not true. Thank you.
Okay. Anyone else on comments on it? Okay, so we'll put that one to bed. And let's go on to draft recommendation 3. And that's up on the screen. This is a fairly lengthy one, as I'm sure you're aware. So
This is.
let's go ahead through.
Sorry.
Yeah, go ahead.
This
Paul.
is. I'm sorry. This is language that sort of brings into line 9-101.1 with 9-101.1. Well, there's some redundancy between 1 and .1. .1, though, the important distinction is it also discusses basically domestic violence against the child's against the other parent. So in a custody case, against the other parent is the relevant portion here. And all it really requires is the court consider that domestic violence when making custody determinations. There were no teeth to it. I mean, there's more to it than that, but really fundamentally there's no teeth to it, like 9-101, which we just covered earlier, which is a good piece of legislation. We're trying to bring into line here 101.1 with 101 that if there is a finding of domestic violence, that the court there's a rebuttable presumption against custody for the abusive parent. And the idea behind that, obviously, is that if the court is to seriously consider domestic violence in child custody cases, then the science out there and the better statutes out there, and there's I think 22 states that have a similar law, is that there is a rebuttable presumption against custody for an abuser, because the types of abuse are going to continue during custody, and that often the abuser will use the child as a way to abuse the victim parent, and it's not in the best interest of the child to have that. And this language here was pulled from the legislation of 3 different states, some of the best provisions from each one of them.
So can I ask a question? Now I'm back to Camille's point, which is that there is a difference between intimate partner violence and child abuse, and a rebuttable presumption against custody to a person who has committed domestic violence. If we define it up in recommendation 2, I mean, we have many, many cases where our clients say that they are fine with the child going with the father, and forgive my gendered, language, but
Right.
But it's just easier than saying he, she, whatever all the time. So I'm just going to say him and her. So they say he's fine with the kids. He's a good father. I want the kids to have a relationship with him. I just don't want to have to deal with him. I don't want to have to see him at the exchanges. I don't want to have to communicate by phone. I only want to communicate by text or email. But it's not, it makes me want to define this further so that, I mean, I absolutely understand a rebuttable presumption if the person has found to have committed child abuse, however it's defined. But I'm really concerned about the pushback we're going to get from the presumption of joint custody people if this is so broad that there's we're going to get pushback no matter what. But I don't know if there's a way, again, like we were saying in recommendation number 1, to define this a little bit further. And I haven't looked at the 22 other states, so I don't know if any other states have, but I'm reading this and I get worried about the political part of this, which is it'll get ugly, which is fine, but
It will. I agree with you there. And I understand there are, and I'll use the same gender as you are, just to avoid confusion. There are the moms out there who state that. Generally speaking, in some of those cases I've been aware of, objectively speaking, we've disagreed with their take on the parenting skills of that person. But quite frankly, 2 things. One, it's not always up to the parent. And if they're in a custody case, then usually they've made that decision that they don't want that person to have custody. That's usually why they're in this and would rely on this litigation. And 2, I would imagine in those instances where the mother is saying, I'm okay with his having joint custody with me, the court could make a finding that the presumption has been rebutted by the testimony of the victim. So I think that there's probably workarounds, and I'm happy that if we could come up with some language to address that more fully, that we certainly should consider that. But at the end of the day, regarding the pushback, to me, at least as an advocate and a member of this committee, this is one of the key provisions, I think, that if we are taking domestic violence seriously in custody cases, that the science and the better practices in those states have done this is to have a rebuttable presumption against custody for an abuser because of what we've all seen, because of the way the abuse has continued when they have that power, and it's certainly not in the best interest of the child to be used as a pawn in that way. So
Paul, I had a question.
certainly.
How does
Hey, Camille.
how does this impact? So sometimes in a domestic batterer will target one child, right, and not the other children. And so how does striking this language in number 3 impact those cases where other children in the household are not physically abused, but they are witness to one child being singled out and really brutalized? How would that impact that?
The only reason I struck that, and we could put it back in, is because I see it as a redundancy of 9101. I think any child residing within the party's household, including a child, if an abuser, the language of 101 is more expansive than that. If an abuser abuses any child, not even his own, if he for some reason punches the kid across the street, then 9101 kicks in. The protection's there. There's a rebuttable presumption against custody for him there. So I just struck this because I saw it as redundant. I'm happy to put it back in and leave the redundancy, but I just don't personally see a need for both of them. But again, I'm not tied to that.
No, I was just wondering what the implication.
Sure, and I should have explained that. And I don't know why they made the redundancy. I assume they made one law and then they made the second one and just didn't consider I don't know what the history of why they did that.
Here's a technical question then. In Maryland, like some states will have a family abuse protective order and a child protective order. So does removing this only allow you to protect a child in circumstances under a protective order, as opposed to just a family abuse order, which a domestic violence victim can actually go to the court and petition themselves? They don't need.
This would have no effect on protective orders.
Okay.
Yeah, this is for custody. Well, I take that back. Any positive effect in this could be used in a protective order, because any custody law is considered under a protective order or any other judicial proceeding that determines custody of a child. So the definition of a custody proceeding is very expansive. I don't see how that will have a negative effect on that. I mean, you would pursue a protective order pursuant to the protective order laws, and within that, the court would have to consider what protections it has to institute under 9101 and 9101.1. Because again, any custody proceeding includes protective orders. Does that address your question? Okay.
Yes.
Okay. Couple things strike me. One is, in terms of our report, we're probably going to create some controversy with what we're recommending, but that's okay. I mean, we have to deal with these issues, and that's what we're all about. That's why we're here. So I think it's important when we have issues or points that we really think are key to this and to making this work. And once again, just to remind everybody, this is for the children that we're worried about. Okay, this is protecting them. So we have to make sure that what we're doing does in fact protect them. And anyway, those are a couple of things that struck me as I was listening to what we're saying. Is there something further that needs to be clarified in this, Paul, or thoughts on that?
I'm just trying to recall if there's another page to this. Can we go to the next page to see if there's any more language to this?
There is more language.
All right. Yep. Here we go. What this addresses, a lot of this is if you have two abusers, and I can't recall which state this is from. If a court, as we know often in these cases, a victim will protect him or herself and will sometimes get arrested or have protective order put against her for scratching the abuser or what have you, or there'll be joint protective orders against them. And this sort of addresses that. The court has to make a determination about the level of violence and who, basically trying to determine who's the real abuser here. And this would be down the road. This could be down the road after, 2 years after a protective order that was given against, joint protective order against both the mother, or mutual protective orders against both mother and father against one another. They can't just say, well, you both have them, you're both abusers. It has to go through a process then sort of to break the tie. And if it can't break the tie, then it would do a standard best interest of the child analysis of which it thinks is the best parent or the best arrangement for the child. Again, I can't recall what state I got this from. It might have been Arizona. I can go back and look. It might have been Arizona, but there were a couple states that had really good language, and this was recommended in. I'm blanking on the name, but it's one of the good articles that was sent around about considering domestic violence in custody matters. It was recommending if you recommending that there should be the presumption against it, but you also have to have a safety catch in case the victim herself has had a finding of abuse against her, what the court should do then.
Okay. Camille?
Paul, is there, I just don't know, I'm not as familiar with the Maryland code as I am some of the other states. Does Maryland have a rebuttable presumption on child abuse or child sexual abuse or anything like that?
Yes, 9101, it doesn't say rebuttable presumption, but that's really what that is, in my view, is a rebuttable presumption under 9101.
Okay.
Nina, yes, Nina. Can't hear you. You're muted.
I'm a little bit unclear about the language in subsection 3 with respect to extraordinary circumstances that warrant the rejection of the presumption. Are there any examples about how has that been defined? Is there any case law or any other definition anywhere in our statutes about what constitutes extraordinary circumstances? Because we want to be careful, I think, about making it an irrebuttable presumption.
Sure.
There's no way to rebut it. What does that mean, extraordinary circumstances? I think we should, perhaps we should use the phrase that's already been defined in the law, exceptional circumstances or something like that.
I could take a look. There may have been examples, and there may have been more in one of those statutes. I could take a look, and I could certainly see if there's any case law under the state this came from that defines extraordinary circumstances. And I agree with you that we can't make it an unrebuttable presumption, and there has to be a way out for a judge to make a finding. I'm not sure how to define it. I do think it should be, and I'll use the word extraordinary in the loose sense. It should not be the ordinary, or the dictionary sense. It should not be the ordinary way. We can't have so much of a carve out that the law becomes toothless. But I agree with you. There should be instances where my example would be domestic violence that occurred years ago. The parent has undergone, there's been no record of it since that, and the victim in that case is now has a drug dependency or other things that would perhaps render her unfit. I think the court in that instance probably should award the child to the otherwise abusive parent.
Yeah, the reason why I raise that concern is that from my days in the appellate division, I know that a lot of litigation was centered around the word, extraordinary circumstances. And my concern is that if it is interpreted as being a hurdle that cannot be overcome, then the statute is subject to a constitutional change. So I think we should choose whatever word we're going to say in subsection 3 should be chosen very carefully.
Just to echo the secretary, we're not supposed to be proposing the language. We're supposed to propose the recommendation. So I think we could take care of that in whatever is the appropriate reporting way by saying, this is what we're getting at, but you do what you do, drafting wise to make it so, as they say in Star Trek.
Okay.
Yeah,
it's just a suggestion. I'm not.
No, it's a good suggestion. I think that matches up with what we've been trying to do. As long as we I think it's good to have the caveat as Paul was outlining to explain it so that when the legislators are actually putting the legislation forth, that's taken into consideration, or that's part of it. That makes sense.
Yes, I agree.
Yes, it does to me.
All right, so on that particular one, then maybe Paul, if you could work on that particular part. I don't want to come back to the whole section again, but on that particular one, we can come back to that in our next meeting. But the rest of it, I think, unless there are any other comments or thoughts about that, let's go ahead, go forward. Anything else to add to that? Okay. Then let's go on to recommendation 4. Any comments on recommendation 4? Okay. That,
I just have a question for Paul on that. What are the implications of that?
Which one is this?
recommendation 4, we're talking about provisions of 9-101 and 9-101.1 are not applicable to child in need of assistance cases.
Right, I'd have to defer to those who do Senate cases. I really don't do them. Not really don't do them. I don't do them.
Okay.
I believe we have other folks
Nina?
here.
Yeah,
who
I
do.
think Nina.
Yeah, Nina does, right?
So this was my request that that this provision be recommended. And I think that from my perspective, the only consequence of this is that there is no, it's going to clear up a lot of confusion about which statute to apply when you're dealing with Senate cases. I think that the juvenile statute is really comprehensive and already gives the court the ability to take all of these factors into consideration with respect to domestic violence and child physical abuse and sexual abuse. But that there are so many challenges to the application of 9-101 in Senate cases, because Michael Lohr can back me up on this. I believe that it was never intended to apply to Senate cases because the juvenile statute was already comprehensive, and this just created a lot of confusion about, is it constitutional to shift the burden to parents when the acting party is the government? And the answer is almost always no. And Michael, maybe you can explain that a little bit more about the legislative history that you were able to discover.
Yeah, and actually, I don't have that specific reference in front of me, but I do have some of the reports from the 80s, 84. And actually, I think it might be in this one. This is the November report that they did, and this is where they created 9-101. Not really on point with that. I did see that, and I can find that and share it with the committee if it's not in our record, but I was just digging for not to go back, but they did make it clear in that report, and I'll definitely share this, and yet allow parent supervised visitations in cases where abuse had occurred in the past and it might continue. So just to reinforce the fact that when they were initially envisioning these laws, they didn't think that supervised visitation in that form should even necessarily apply. It was something that might apply in certain circumstances, and we're clear it was supervised. So, but yeah, I'll get information on the Senate background, but that was a separate process that was in place, and this was trying to fill a gap that wasn't in place for the custody issue.
If it's possible, is there a way to, is there a separate statute for children in need of assistance? It's like a whole other statute?
It's a whole other statutory scheme. It's in the Courts and Judicial Proceedings article.
Okay. Is it possible
and,
for all of us to actually look at that just so we can all read it to see what it says? And is it only applicable to adolescents, or it's all children?
So the Department of Social Services can file a petition for any child that is under the age of 18, but the court can retain jurisdiction until the child is 21 years old.
Wow. Okay. Wow.
And it's for, any allegation of abuse or neglect.
Yeah.
And it's all encompassing, and it's its own, compact statutory scheme, which addresses these issues. The problem that comes up with 9101 is that it doesn't specifically say it applies to SINA cases, and yet it is being applied. And so all of the presumptions, they create, constitutional issues in the cases that involve the government, where it's the government taking the child away from the parent.
So we're talking about foster care cases and things like that.
Exactly.
Okay. Would it be possible for us, Mr. Secretary, for us to just read that statute so we know what we're agreeing to?
Sure.
Okay.
So, okay, so we'll come back to that one. What I might ask you to do is, I don't know that we want to wait till the end of the month. So if you all could take a look at that, if you have some further issues on it, get back to us by email. Let's say by next week at the latest.
And it can be found in child, yes, somebody just put it in the text.
Yeah, Jen just gave us the reference, I think. Okay, it makes sense that, we could put a recommendation in that clarifies that. Okay. All right, draft recommendation 5. Can you scroll that up for us? Okay, great. Let's see, who worked on that particular one? Could you bring us up to speed on that particular one? Friendly parent statute.
Mr. Secretary, I believe this was sort of a general recommendation that came from, I believe it was Dr. Saunders. And so based on some instructions from your office to just sort of go through the recommendations from Dr. Saunders to see what we could propose as recommendations. So this, I don't think anyone specifically did this, which is why it's a little more vague, but I think it sort of provides what we would, want to think about as a draft recommendation that could certainly be looked at a little further when we actually do the legislation.
Right, and I do recall the issue of assessing costs and council fees, and that was a big issue, obviously, for a lot of parents that were on the side of depleting everybody's resources, as we recall. So that seems like a good one. Does anyone have any other things to add on recommendation 5? Yes, Camille. You're on mute, Camille.
I think it warrants a little additional discussion. I'm all for creating a way to, exempt parents that are actually acting in their child's best interest for withholding the visitation. But I think there's a lot of room here for the judiciary to misinterpret what a reasonable action might be. And I'm sure it could go either way. It could go too high of a bar, too low of a bar. But I think there's a lot of things that happen in the context of a visitation order, or as even a supervised visitation order, that seem reasonable to the protective parent, but may not meet this reasonable action threshold. I don't know if I'm articulating this well, but let's see if I can give some examples, like on a supervised visitation, leaving the child alone with the offender, or on a supervised visitation, or even just a general unsupervised visitation in these types of cases, the offender giving notes to the child to manipulate them, intimidate them, or scare them in some kind of way into recanting or something like that. So I think there's just a lot of room here. I would appreciate some additional discussion on how to flesh that out. I agree with the recommendation generally, just that I think we need to be very careful about how we make what exactly,
So
how we
why don't we just, the statement you just made is not bad. I mean, that sort of covers it in general terms. And again, we're making recommendations here. We're not drafting the language yet. But I think the point that you make conveys the concern and the limit and some limitation on it. So we don't have a lot of time to make, to do the whole report over or to, to majorly modify it.
Right. Okay.
So I think it'd be good. The statement you just made seemed to me, if we can capture that and put that in, then does anyone have any objection to that? Okay. So why don't we capture that in and with that understanding, then let's proceed.
Okay.
Okay. All right. Our next recommendation is number 6. Okay. Give me a second. I just want to make a note here. Okay, recommendation 6. Thoughts on that one?
I would just include in the child's safety that it's both physical and emotional safety.
Good point. Okay.
That word resolve safety risks, I guess the word resolve I have an issue with. Sometimes these cases are on a continuum. There's no hard and fast resolution with one court proceeding. So I think we need to say that the child's safety is always the priority, even if the case continues to be ongoing or whether there's questions about the degree of the abuse or things like that. So the word resolve stands out to me.
Okay, well, let's, there's a good
We just
comment.
change it to assess, Camille.
Yes, that's a better word. Thank you.
Okay, sure.
All right.
I think I pulled that from the congressional resolution, the resolve. So
Sure.
assess. I will make that change.
Great. All right, let's move on then to draft recommendation 7. Comments on that one? Okay, seeing no further discussion, we'll assume that that's acceptable, and we'll move on to draft recommendation 8. Comments, thoughts on this one?
When you say experience, do you mean survivor or do you mean expertise? Or both?
Let's see, who came up with that particular one? Anne, was that one that you did? I'm sorry.
Actually, Secretary, I actually think that was Lori Ruth.
Uh-huh.
Lori, wasn't that something you discussed early on?
I'm reading it and trying to, I'm not sure I would have made that recommendation, to be honest with you, because I think that judicial nomination commissions are political in nature, and there are all kinds of reasons why governors or jurisdictions appoint. Right now, I can't even recall who's in charge of naming the memberships, but I think it's the governor. So
I know, but you originally talked about a committee that was weighing in, and I believe it should say who has expertise, to Camille's point, in domestic violence and or child abuse. Someone on that committee who's with the others to then move on to the governor, the first step. I
So the
remember,
regional nominations commissions?
is that right, Jen? Is that what, I think that's what it was.
Yes, Lori, this was something I think you added to, I believe I messed up with the word experience. Expertise is probably the
Yeah.
word that was intended, so I apologize there. Lori, this was something I think you sent in an email after the small group meeting where we were discussing the draft recommendation 7, sort of the specialized docket concept.
Yeah. I mean, I'm not a, you know, I clearly can't remember anything, so forgive me.
Okay.
But
Yeah, that's not-
I'm not opposed to this and that. I just don't recall my thought process if it did come from me right offhand. I can't recall it. But I agree with expertise rather than experience.
Yes,
I mean,
I'm sorry. I think that was my mistake there.
yeah.
And Lori,
Okay.
we thought that was a great suggestion. And again, echoing on Secretary Womensmith's point, you know, this is we want to create a concept right now. And I think that's a great suggestion. And I think that is something that's appropriate and should happen in the future. So whether it happens next year or 10 years from now, whatever the case is, obviously,
Good. Yeah.
we want to put it in there.
Yeah, that makes sense.
Right, and I think the intent of this is even if that expertise is not on the commission itself, but having the judicial nominee appear in front of one of the groups that has to answer these questions specifically would be important, because we know that family law, you know, judges will do family law cases. And so I think this one could be a little written more broadly, but I think the intent is a good one.
Yeah.
Okay. Sounds good. All right, let's move on to draft recommendation 9. Again, a pretty long one.
For number 2, under the things that should be included in the training, I would put the impact of adverse childhood experiences and complex trauma on a child's developing brain.
Okay.
I'm sorry, Camille. I'm sorry, not Camille, Claudia. Could you do
Sorry.
that one more time for me?
Yeah. And to say the impact of adverse childhood experiences and complex trauma on a child's developing brain.
Okay.
And we heard.
This is Jen Shaw. I also sent, not to everybody, but to the subgroup, just some suggested language for this section as well. And actually something very similar for number 2. But I did wonder if we could say the impact on a child's neurodevelopment, because we're talking about child abuse as derailing development in several domains. So just language, and I know we're not worried too much about language now, but the other one was if we wanted to include chronic toxic stress, and I say that because in court we'll often be asked about trauma, and there's a pursuit of finding the traumatic event. And in many cases, what we're talking about is exposure to either domestic violence or chronic stress. And of course, you know, if there's been a history of abuse. So chronic toxic stress, if we wanted to include it. So then it would be impact of trauma, which is different than complex trauma, but trauma, complex trauma, and toxic stress on a child's neurodevelopment. And I sent that to the subgroup.
And Dr. Shaw, could you just repeat that one more time? Just, I know the subgroup has it, but since this is an open meeting, we want to make sure that.
Yeah, sure. I just know that that language is to be determined later. I was just trying to get it as broad as possible. So definitely the inclusion of complex trauma, but complex trauma is separate from trauma. So they're 2 different terms. So I think you'd want both in there. So the impact of trauma, complex trauma, and chronic toxic stress on a child's neurodevelopment.
Excellent. Thank you very much.
Yeah, that's good.
For Claudia and Dr. Shaw, I'm the one that added a child's response to trauma may vary. The reason I put that in is I sometimes see in cases where people misuse attachment theory as an explanation for the child must not be traumatized because they have some type of attachment to the abuser under a assessment or evaluation session, and therefore the abuse didn't happen. So it's kind of misused. And I think that there needs to be a better understanding, not just about how trauma impacts the brain, but also how it manifests and how children react in different ways. There's no one set reaction or functioning for a traumatized child when they're in the presence of their abuser or not in the presence of their abuser. So I just wanted to make sure that we cover that variance.
Yeah, I'll just say that I have a working on separate kind of elements of this kind of training, and just to capture it here, I thought the response to trauma may vary, because what you're talking about is it depends on the child's cognitive development, their relationship with the alleged abuser, and whether they're internalizers or externalizers, whether it's betrayal trauma or single incident trauma. So you're just trying to say it's no longer did the child scream or tell someone, that there be a consultation, or at least through a training on what else it can look like, the internalizing behaviors, the delayed response, the shifts in behaviors and emotion. So may vary, I thought, captured that for this, and then the document I'm working on of specifically what those variables are for later down the road.
Yeah, I just wanted to make sure that may vary was okay with the
and I mean, if you want to change it to does vary, because it's just a fact, right? One 7-year-old is going to be different than a 7. One 7-year-old will fight, and the other one will tell 10 years later. It just depends.
Right. Great.
That makes sense. Let's fix that. That's good. Okay.
I also wondered if we could just go back to the first one. I think it just says child development. And if we could insert infant and child development, that's 0 to 3. And really specifically that there be a baseline of what is neurotypical infant and child development, which is important if the rest of the training is what event or events or stress created a derailment of that, right? And that's why you're arguing for all these protections, and including the psychological safety is essentially which parent can promote kind of repair of that derailing of development. So just to introduce the language, starting with what is neurotypical, so you can then know, well, why did this domain of development shift? So that was just a suggestion that it say neurotypical infant and child development, that be a baseline requirement.
Okay, that makes sense. Anybody else have different thoughts or add to that? Okay, let's move on. Could you scan up the draft recommendations? That's great. Thank you. Okay. Other comments on the points?
I had something on number 3, and this may be in a section further down, but where it says the limitations of local departments of social services. Is it possible to also add the limitations of forensic interviews in cases involving young children? Unique considerations when investigating children with a complex trauma presentation, whether that fits here or elsewhere. Does that make sense for this section?
Goes to me, but go ahead. Anybody else?
Do you want to put that under number 9?
Yeah. Let me look at.
I understand what you're.
Yeah. Go ahead.
I understand what you're. Well, let me hold off on that. I understand what you're trying to say and why you want to put it in number 3. And it may be and I don't know if we have it adequately protected, but what a forensic interview even is, right? Like what it is, and a credible narrative response. Why is that so important? If a 3-year-old discloses, that's pretty phenomenal. And I think that, so yes, I think that might be captured somewhere else with, if you have, what is a forensic interview? What, what does the disclosure?
Yeah.
Let me scroll down, but I understand what you're saying.
Yeah, I'm just trying to capture that. In a lot of the cases that I am trying to fight for children's disclosure to be believed, the forensic interview is used as, well, it's unfounded, and then it's 1 or 2 interviews. So where is that, just so that judges know that, hey, the forensic interview is more appropriate for this kind of trauma, or where there's not a relationship trauma or anything like that.
Absolutely.
But it's limited in most of the cases that come up in court for custody.
Absolutely. I think, and if it's not already in this large list, then I agree that there could and should be something very specifically. What is a forensic interview, and how is that a tool in court, right?
Why don't we make it a separate item? And we can do that as 17 if you want, and just give us the language for that and get that to Jen.
Great.
Okay.
Yeah, great suggestion.
All right, let's do that. And then other than that, I think we're good.
On number 8, I wanted to add something. Are we still talking? Yeah. Just thinking about our last presentation and thinking that this recommendation should be a little bit broader, to include something on credibility vis-a-vis domestic violence and child abuse, including the impact of trauma, and
I'm not sure I'm following you on that.
so
Could
on
you, come back on that a little bit.
so this really looks at custody bias, impact of implicit bias. And when we had the presentation by Dr. Epstein, she really talked more broadly that there was not training on credibility. And it's really judges' sense of the credibility is a gut feeling. And, I trust this person or I don't trust this person, and not understand multiple aspects of it, including how trauma impacts many of the things that they would take into consideration around trauma. So I probably need to think about this to make it a little bit more, but I would say just some training in how credibility is impacted by survivors of trauma.
Is there,
How
yes, could you scroll up to the last part of that particular one? Because there's a statement at the end that talks about the judge, before a judge is assigned to preside over. Maybe the cautionary thing that you were just saying, maybe we can just add that into there. Go ahead, Jen.
Or, Claudia, if we were to sort of change that recommendation and just say that it would be broader, and that when we actually draft the legislation, we would pull in some of the elements from Dr. Epstein's presentation, and would that work?
Yeah, I just use the word, if you can use credibility in the, I think if you use credibility in there, because it's a much broader than implicit bias.
Credibility is mentioned in number 13. Claudia, can you look at that? Is that a good place for it?
But that's really of a child witness. Just that's not doesn't take into account. I mean, it's usually.
Do you want to add adult there?
The parent, the protective parent.
I think we can easily figure out
Yeah.
the best place to put it, because we have a
Okay.
few other changes to
Yeah.
incorporate.
Okay.
So that
Okay.
it may not be 1 through 17 by the time we get through adding everything, but I understand what you're saying.
Yeah.
I think
Okay.
if that's just elements of credibility in line with Dr. Epstein's presentation,
Right.
if that's acceptable, I
Yes.
think okay, perfect. Thank you.
And I would only just say about number 8, the bias of presumption of coaching in custody cases, I think is such a core element of this work group and these procedures. I wouldn't want that to get lost. Like, that is the dead center of something that we see all the time. And so I just kind of want to.
Well, why don't we say one of the really core issues is this particular one?
Yeah.
Just add that in.
Coached. I mean, that bias, is one of the cores of our work and where we see it go awry.
Yeah, it's an excellent point. You're absolutely right. We talked about that a lot. Okay. Any other comments on that particular recommendation? Okay. We're moving along to recommendation 10.
I have an overall comment about this and the one on evaluators as well, especially with this. I'm not sure. I didn't do a direct comparison of the points that the judges need to learn and the attorneys need to learn. I understand why attorneys need more because they have direct client contact. So, applicable representation guidelines and standards, that's additional. But I think they should at least have the same what we're requiring of judges. I noticed too that they have less hours, and that just I think logically doesn't make sense to me, because judges come out of lawyers, and we ought to be really building strong advocates, attorneys that understand this before they become judges, and they should have the basics. So I think those two things should be identical. We could add a couple things on top for the lawyers and the evaluators.
Yeah, Jennifer, I would agree that I think we need to sort of make sure these two sections are very consistent and sound the same, so that they're all coming in with the same foundation into those proceedings. And I agree that they probably need some additional hours there. The guardian ad litem's role can really make or break protection for a child. So they're really critical.
Does it have to be the same though? I mean, does the child's privilege attorney really have to have 16 hours? Don't we really want to highlight the best interest attorney here?
I think we're trying to create a system here where, people working on these cases really understand. And I mean, 16 hours, I really don't understand how that's going to do it with, I know a lot of courses, you can do that in that short a period of time, and you're not going to have too much expertise.
Also, Michael, just anecdotally, I don't know of attorneys who serve only as a privilege attorney and don't also serve as a BIA. And so I think it's it's got to be a very small percentage of any. So I'm not too concerned about making privilege only attorneys do more training, so much as, like Claudia says, making sure they all have enough training.
And is 20 hours sufficient for the training overall? When we look at the judges must receive at least 20 hours of training that include the topics above. I'm asking you guys, I don't know if that's even sufficient. Is that enough?
Probably not, but I don't see how we're going to get more than that. It's a practical matter. I think you're going to have a hard time finding enough space in the calendar to do that for people.
And I mean, they have their 3 days of family law training when they get appointed to the bench, and then they do have ongoing required training. So I don't know whether this is changing their curriculum or whether this is in addition to.
My apologies. I thought this was for the 20 hours for BAAs. I apologize. That was 16 hours. We're talking about judges here.
Well, we were talking making them the same.
Yeah.
Claudia
Okay.
recommended.
I see.
Fine with making the BIAs need 20. I think Ann's question was, is 20 even enough for judges? And my point is, I don't know whether this is on top of the required training they get when they get appointed, or whether it is on top of their their continuing education that they're required to have, or whether this is just a curriculum change to the training that they are getting.
Right.
Well, I think it would be on top of that, because these are, the special ones that actually have this training that are hearing these cases. So it would be separate from like the baby court judge and things of that nature. So this would be a whole separate training.
Yeah, I agree, because it's saying 20 hours on these topics, and to the extent any of those topics are specifically are covered, then at least theoretically they don't need to be recovered. But I don't think
they cover our recommendations to the extent. I mean, there may not. Yeah, Lori's agreeing. I don't think they cover any of that. So the 20
because they
hours,
have so much to cover, they're not going into the weeds of the dynamics of domestic violence. They're talking about the law. This is a protective order. This is the definition of abuse, so that they can get on the bench and make rulings. So they're not doing all the voluntary trainings that judges sign up for, or maybe this level, but the basic training I would feel comfortable saying is not reaching this level of specificity or expertise at all. So this would definitely add to their education.
well, and that's the whole point of this exercise, right? To get them to have.
So why don't we make that comment too, that, while we're talking about 20 hours, but that we are concerned that this may not be sufficient. Again, we're making a recommendation that we think it ought to be a little bit more than what's been specified here. So cover it by just saying that.
Can we also go back to the last page? There's a phrase there. No, whoops, what happened?
What are you saying? I'm sorry.
What recommendation?
The best interest one, the first part of that.
Page 6.
Yeah, it says, unless waived by the court. Do we want to remove that?
It's a good question of what that means. Like, what's the anticipated fact pattern of unless waived by the court? Like, you're just a good guy, so I'm not going to make you do this training. Like, why would the court waive the training requirement?
Right.
Or under what?
That's an excellent point. That makes eminently good sense. Yep, good catch.
What about access? What about we haven't written in here how they're going to get the training. There may be access issues in some parts of the state.
Well, I think, isn't that for the administrative office of the courts to figure out, to make sure that they are providing this training to judges, if it's mandatory, in a way that's accessible for all of them?
Or attorneys. I think they will. Yes. Look, we're doing this via Zoom. The world has changed for the better in terms of access in that regard. Yeah. So I don't think we need to address it in our recommendations. It's sort of an if you build it, they will come philosophy. If you make the recommendation, they're going to figure out how they have to do it.
Good point. I agree. Okay.
Mr. Secretary, may I just make sure I have all of the points down? So we want to take away the unless waived by the court. That's a requirement now. It's not one that we were recommending, but no one suggested that we strike it until now. So we'll eliminate that possibility. Yep. And then increase the 16 hours to 20 hours. And we do have at least, so at least 20 hours to make it comparable with what we're asking for the court. And then we'll just make sure that the two, again, I mean, I was really just working on what the subgroup B gave me. So I'll now go back and make sure that if we have it in the judicial training, that is also added to the
Right.
BIA, et cetera, training.
Yeah,
Does
you're
that
spot on,
capture
Jan.
everyone's basic commentary and feedback?
Yeah, I think the only other thing was that you know, we recognize that still may not be quite enough.
Right.
Training. So I think that would be helpful to caveat as well.
Okay.
Okay. All right, let's move on to recommendation 11. And let's see, Senator Lee or Senator Cardoza, do you have any, or Michael, do you have any comments on that?
I do.
Great.
So I want to thank everybody for all the hard work that's gone into the recommendations, especially our challenges of not being able to do this in person. As far as the role of the custody evaluators, I wanted just to take a step back as we go through and make suggestions and revisions. I just wanted to give a little context. So whatever changes we make to the recommendations and as we think forward to the legislation, what I found significant in our dealings and the hearings that we held up until this point was the fact that judges were depending on the recommendations of the custody evaluators, and that we found that there was not a uniform standard or process that I think we all agreed we wanted to make improvements in this area. So thinking along those lines, I think that any of our recommendations, especially I think to hopefully secure support with the courts, is to show that a recognition of that the judges do depend on these recommendations, and that we want our recommendations to be a helpful tool in this process. So I just wanted to give the context because I learned a lot in the process itself just by listening, and I'm just trying to anticipate how we can gain maybe support in the court system for some of these recommendations. So that's just a little bit of background. And then as far as, the walkthrough of the recommendations, we had a very active subgroup, and I would defer to my colleagues to flush those out.
Okay. Would someone like to add to that?
I would.
Please.
Thank you, Senator. I wanted to raise two issues. One, I think that custody evaluators have become a sort of cottage industry in their own right, and they can even push a litigant into bankruptcy. Sometimes they charge $10,000, sometimes they charge $40,000. I can be incredibly financially burdensome on the particularly on the protective parent. So is there a way to add to this recommendation that there be some type of cap on fees? Right now, it's kind of the Wild West there. The other thing I would want to include is that there be a standardization for qualifications for custody evaluators, specifically in domestic violence and child sexual abuse cases. Sometimes the custody evaluator will claim that they have an expertise in child sexual abuse simply because they've worked on evaluation in child sexual abuse custody cases, which is not really experience or expertise in any way. And then the harm that their evaluation can do can sometimes undo all the work of a forensic evaluator who actually is an expert in child sexual abuse. So sometimes the custody evaluator then ends up becoming undermining the work of the Child Advocacy Center folks. So I don't know how everyone else feels about that, but I feel like maybe if we can provide some more stringent standardization for their qualifications on specific cases, I think that would be really critical.
So I hear you, and I think as we go through the specific recommendations under custody evaluators, we can figure out where to strengthen some of those points. So to your first point on the draft recommendation 11 about this information, this recommendation about the information provided to the parties regarding the role, availability, and cost of a custody evaluator, I thought this was important, and which is why Senator Lee and I introduced the legislation, because from our hearings, we learned that some of the parties didn't even know that this was a tool that was available to them. So if your point is that on the court shall provide the information, we can, is that where you would, I'm not sure if that's where we would insert that there would be a cap on fees, but I certainly would support that, because I think we also were concerned that we didn't want the party who had the most financial resources to be able to, overly influence the outcome based on the fact that they just had those additional financial resources. So again, I don't know, I'm looking for a little maybe support from our attorneys on the workforce, but I don't know if that's where you would cap the fees or not in this draft recommendation 11.
What about 12? I thought 12.
Okay, I see. Yeah, okay, I got it. So the first, I guess the first recommendation was pretty straightforward, just to provide this information.
12 talks about the fees, and then in 16 we get into trying to find, or at least recommending the finding of funding for people who have a difficult time affording this. We want to make it less burdensome on individuals with income, lower incomes, so that it's not such of a problem for our imbalance between incomes between parties.
Going back to the draft 11, and maybe because I'm always sensitive about us, instructing another branch of government, a court shall provide information. If we, and again, I'm assuming maybe put some language in there that we would work with them on what, the best way to share this information. In other words, I really would like this seen as helpful to, the parties involved, as opposed to being viewed as something that the legislature is telling the courts to do. Does anybody have any thoughts on that?
Senator, this is Lori Ruth. I mean, here is the reality, right? Every case is not treated the same, even in every jurisdiction, because you have cases where one side is in default. So they don't do a scheduling conference because there's the defendant hasn't filed an answer. So while I would say, broadly speaking, that in family law, the scheduling conference before a judge or magistrate is when you are given information like this, and it's either going to be go across the hall now to the court, to the custody evaluator office and make an appointment, or here's a list of the private people we use for the court. And the Women's Law Center's testimony says that the administrative judges are tasked with setting a fee schedule. So I can't recall right now where I got that information from, but that's what our testimony said in support of your bill. But not everybody even gets a scheduling order. So if you use shall rather than should or are encouraged to or any other language, the court will be required to devise a method to inform people who are involved in cases that aren't taking that typical first thing you do at the court is a scheduling conference. And that is a lot of cases with self-represented litigants. So I prefer shall because it does force the other branch of government, which I totally appreciate your uncomfortableness with that in some ways, but it does force them to develop policies to inform the public who just don't know these things. And so I don't, I prefer the shall language. And, they put it on their website. They send it with the notification of the next thing. They develop the pamphlet that they hand out with the whatever, they'll figure it out. But if you don't make it mandatory, people like now are going to fall through the cracks.
Okay, I agree with that. So just give them maximum flexibility on how they
exactly.
Okay.
Again, it's like if you tell them they have to do it, they're going to figure it out.
Okay.
And I prefer the shall language.
I'm okay with that. Just, let's just give them the flexibility on how they want to do it.
Okay.
And I don't know if Senator Lee, since we, had that bill together, if she had any other comments or thoughts, or Michael, on that recommendation.
I think you covered it.
Okay.
Okay. Well, thank you very much on that. Let's move on to 12. And this is where maybe we should address the issue of putting a cap on fees.
Should we just add that language?
I think that's a good spot to do it.
Okay.
So could I hear from like Jen Shaw or somebody who does custody evaluations as a private practice, and what that would mean for them from a business model? Because I recognize the cottage industry, comment from earlier and whatnot, but I'm uncomfortable. So, we lawyers who work statewide and stuff, we always talk about Montgomery County. And, if people in Montgomery County want to spend $40,000 on a custody evaluation, who am I to say to them the evaluator has to do all the work, but for only $10,000. So I'm not sure. I guess I'm uncomfortable with the intervention in somebody's business model. And I think that there are certainly issues with people who can't afford something. Just like we waive the filing fee when people can prove their indigency, they don't have to pay the $165 filing fee to the court. But there's a piece of me that is uncomfortable telling therapists or whoever it is that does these private custody evaluations that they can't get paid what they're supposed to be paid. And I don't know the answer. I just wanted to raise my uncomfortableness with it.
So Laura, what is you just mentioned that they should be paid what they should be paid, but what is that?
I don't know. That's why I said maybe you could ask somebody here. And I think Ms. Shaw is a therapist. How they decide what fee they're going to charge, and right. Or if they only work in jurisdictions where the court says pay the evaluator from this list, pay the evaluator $3,000 max, done. And so and then there are all the places that use their own court evaluators, which I'm much more familiar with. So there's a piece of me that's,
I can just speak to the individual private practice piece, and only in Virginia. So what unfortunately is typical here is there's a handful of custody evaluators, and they all charge what they consider a standard fee for that work. So around here, that's about $35,000.
Yeah.
The vast majority of clients we see cannot afford that.
Right.
So the backup is they go to court and they go through a mediation process, which at least in Virginia is laser focused on some kind of negotiation and a final compromise. Mm-hmm. So the gap is, if it's a mediation process because it's more affordable, the mediator doesn't have to gather any information from anyone who's working with the child. And frankly, either does a custody evaluator. It's hit or miss. It's personal kind of philosophy. So if a child's working with a therapist, the custody evaluator may or may not take data from that therapist to make the evaluation, which is something I added to a later section. That for that not to be built in this cases is insane. right, for a custody evaluator not to seek out information about the child's functioning and symptom presentation. The problem here in Virginia is we don't have custody evaluators that are affordable and adhere to those standards of gathering data from the sources of information in the child's life. So I don't know the answer to that, but they set their fees. They set their fees compared to other evaluators. So if one charges $25,000, another $27,000, it doesn't matter. Anything over $5,000 is completely unaffordable for the vast majority of these families.
So what does the court do when you have two people who are making minimum wage and come in and they say, we really need a custody evaluation? And the judge or whoever says to them, well, that'll be $30,000. They then say, well, we can't afford that. And then they say, okay, then you get mediation and you don't get a custody evaluation?
Typically it ends with a joint legal custody, a very simple argument of let's split it, joint legal custody, and the child's then at risk again. I've never heard of a court set a fee. It'll just say pursue a custody evaluator. The gap is that they make that recommendation, the family leaves the courtroom, there's a waiting list of 9 months and it's $30,000. And then the parent has to come back and say, I'm sorry, I couldn't get one. And the judge says, well, you had your chance.
So none of the Virginia courts have court-based custody
They do,
evaluation?
but it's more mediator and coordinator. So an evaluator is supposed to be taking information about both parties, but also a parent capacity, right? And
right, I get it. I mean, here we have separate, you do both often. I mean, absent domestic violence, you go to mediation, it's required for custody. And it is a settlement. They want to settle the case, so that's not an evaluation in any way, but you can also have a custody evaluation. And my point is the court custody evaluations are free or low cost. But if you don't think that's good enough, or if you have money to spare, you can go out and get your own $35,000 custody evaluator. And I just, I mean, there are terrible inequities with all of this. I totally get that, because the custody evaluators that work for the court are overworked and underpaid and can't spend as much time as you probably do in a private evaluation. They do reach out to people like, a therapist of the child, or the neighbor, or whoever is factually relevant. But I'm not, I don't know. I mean, I bow to the will of the group, but I think that setting a maximum fee is wrong to private industry, even if we understand the negative side effects of the private industry that's grown up around custody evaluations. I'm just uncomfortable, and it's not, I don't know.
Okay, are there any other thoughts from anyone else on that particular topic?
I think that Dr. Shaw made a great argument for why we probably need a cap. There's a lot of economic space between indigent and wealthy. And the custody evaluation fees are really off the chart. So I think we definitely should do something.
But the business, it concerns me, because Dr. Shaw and the other 6 people who do this in whatever are just going to say, well, then we're not going to do them anymore. And then the people have no option. I guess you get a cottage industry of therapists or whoever who are going to say, okay, we'll meet that cap, but I'm not sure.
In my view, and I may be an outlier here, I feel like specific to child sexual abuse cases involving custody, that the custody evaluator is a negative influence on the process. It is not particularly, of all the cases I've seen.
You're not an outlier.
They get wrapped around the axle on parental alienation and all that's friendly parent garbage. And they undermine the work of the experts at the Child Advocacy Center and the forensic evaluators and the therapists that are treating the actual child. So if the net effect of this is that it elevates the evidence brought in by the forensic evaluator and the child's therapist, and lessens the influence of a custody evaluator because they drop out because they don't want to do it because they can't make $40,000 on these cases anymore, I'm all for it.
That's really interesting, Camille. Thank you.
Sorry, that's how all the cases I've seen, they just said they're not a positive influence on the process.
Camille,
Okay, Ann, go ahead.
I agree with you 100%. I think this is an ethical issue as well. And we don't want the outcomes of these children to be driven by money. This is not why we're doing this. So I think it is imperative that we look at this and let's dissect this more, offline. Because I think it's really important for us to really address that because it's money driven.
All right, let's come back to that one. I want to move this along a little bit. We have about another 15, 20 minutes, and we've got a lot of recommendation to go through yet. And we don't want to just bottleneck all that for the next meeting. So that's a good suggestion, I think, Ann.
Mr. Secretary, may I weigh in real quick?
Please.
Just to see, on draft recommendation 12, if the group agrees that the custody evaluator should have to disclose policies, procedures, and fees prior to engagement and getting the written sign off, we don't really have to decide with that recommendation what any cap on those fees should be. I think we could just look at that as a separate recommendation that we do early on. Later on. And the recommendation 12 could just simply be, we want to make sure that the parties are aware of what they will ultimately be responsible for paying, whatever we decide that's going to be later on in another recommendation. So we may not necessarily have to revisit that. Yeah, we could the cap on fee could be a potential other draft recommendation.
Right.
In other words.
I think that makes good sense. I agree with you. All right, let's move along to 13. Any comments on that, on 13?
Yes, I agree. This is to me a due process issue. If the custody evaluator is a court employee, and I'm fine with that as custody evaluators if you're going to have them because of the issues we raised before, because they're not charging anyone. But the rules provide you only have 2 hours to depose them, and if you have 3 different lawyers, one for the mother, one for the father, one for the children, that's 45 minutes a lawyer. And I've gotten these reports that are 100 pages long, literally. There is no way you can depose somebody meaningfully in 2 hours, let alone 45 minutes if that's all you have. And I think 6 hours is a good compromise. Perfect. It should probably be longer, but I think that's realistic, is 6 hours for a court employee, because then you're basically getting a whole day with them.
All right. Any other thoughts on that?
I have a question of clarification. So this would go just in cases with allegations of child abuse and domestic violence, that the custody evaluators, their extra time?
I mean, that's our charter. I think I personally wouldn't limit it to that. I think it's a due process for everybody, but certainly if that's what we're required to do, and that's what our mission is, we could put that in there. I think because it's a due process issue, I think any litigant should have more time with them than 2 hours. But if it goes beyond our charter, then we can put the language
so
in.
we're all right. We're making it as part of our report specifically to this, so that's fine. I think we're good. Okay. All right. Let's go on to 14.
This is Claudia again. I think we should make this mirror again the judges training and the attorneys training, with specifications about specific training that's just specific to evaluators. Being an evaluator, I should say.
Okay. So we can do that, right? Jen, you can work that, right?
Right. We'll basically make the training requirements consistent throughout judges, custody evaluators, and training. Just tweaking words as necessary.
Right. Okay.
There was the one question for discussion. Would we like the ongoing? I'm assuming with this recommendation, we'd also say at least 20 hours and then ongoing training of at least 10. I don't think anyone in subgroup C had weighed in on that specifically. So I had that for a question.
Thoughts on that?
I think that should be ongoing, just as the other.
Ongoing.
Okay.
Okay.
So topics and hours are both consistent. Okay.
Consistent, right. Great. Okay, 15.
I would recommend here that we need to break this out by type of abuse, so that people that are retained as custody evaluators in cases that involve child sexual abuse allegations or findings have a specialized expertise in that. And I think that would mitigate a lot of the harm that they cause because they don't have that specialization. And that might also be applicable to domestic violence cases as well, I think.
Would the training be better than a master's degree, in your opinions, whoever put this in?
Yeah, it's not the training so much on 15, it's the qualifications and expertise that they would have to have in order to even participate in those types of custody evaluations. So the training is under 14, but 15, I would suggest requiring some level of experience and knowledge and training by type of abuse.
Okay. Anybody have a different view on that? Okay, Jen, can you capture that?
I believe so. Thank you.
All right, great. All right, let's go on to 16.
Maybe this is where we talk about a fee structure or a cap.
Okay. And we certainly heard a lot of cases of testimony by people about the impact of breaking, basically financial breaking of one of the parties. So I think that is one that is very key. So what's suggested language for this one? Do we have any thoughts on that?
Maybe mandate a fee structure that alleviates any financial hardship on the litigants, and then creates a cap for custody evaluators. So sort of it takes into consideration their various income, but also doesn't allow them to just charge $40,000 or $60,000 regardless. The kind of,
right.
So you can't go over a certain amount, but it also takes into consideration their income.
Sort of a sliding scale of.
Right.
Okay.
But beyond just indigent, because I think that
Right.
what happens is if you have a domestic violence victim who is separated from the primary breadwinner, their ability to pay is going to be dramatically impacted upon that separation. So the primary breadwinner might have more of a means to be able to pay than the person who, might have been a stay-at-home parent and has to go back out into the workforce at sort of an entry level. So I think it should be more than just indigent. It should take into consideration all the income levels of both parties.
And it also take into consideration access to family wealth, because I've come across circumstances where someone might not earn money, but their parents pay for all of the litigation costs, and it really skews all of the accounting.
That's interesting. Yeah.
Yeah. Good point, Michael.
Mr. Secretary, on this and maybe Jen can help with this. On provide enhanced funding. Where's this funding coming from? I guess I'm just I know that's issue is separate from the whole cap issue, so I'm trying to understand the provide enhanced funding. And maybe I just need to better understand if there's already some assistance available for these parties now in the process. Are we proposing new funding of assistance for these parties? I'm not clear on this recommendation.
Sure. Yes, there is funding available. People can get help with a best interest attorney with, in some instances, supervised monitored exchange programs, just like you can. I think Lori was the one that raised the point, just like when you have a filing fee waived. So then I guess weaving in Camille's point, sometimes you may sort of be cut off from access to that funding because maybe you have money above a certain amount, but it's still a hardship for you to actually pay for an attorney or to actually pay for, $40 every 2 weeks to have the supervised monitored exchange programs. So I think it was really just a general recommendation that this is a financial hardship for many parties who, may not be what you would typically consider indigent, but it is important and that somehow there should be enhanced funding for it. We certainly haven't talked about any certain fee or how much that would be or where that would come from, but just a general statement, I guess, of support that we recognize this as an issue because we've certainly heard a lot about it, at the work group meetings from various litigants in the process. Someone else feel free to jump in if I misstated anything there.
Well, Senator, I sort of agree with you in a sense. It's easy enough to say provide enhanced funding, but the money has to come from somewhere. And the concern that we always have is they're going to take the money out of another budget pool. So instead of funding domestic violence lawyers, they'll just have to cut all of our funding, quite frankly, to pay for free custody evaluators in the courthouse. So, linguistically, you could say, emphasize looking at opportunities for increased funding for custody evaluators or something less stringent than provide enhanced funding, because obviously it's always a finite pool, and the judiciary gets their budget and then they have to pay for what they can pay for. So,
Lori, we can certainly work on that a little bit. I think, when we would draft the legislation, as you've seen with some of the other grant programs or places where we do recommend increased funding, sometimes there's language put in that this funding is intended to be, to not replace any other funding that is already given in the supplement. I didn't put all of that in the recommendation because we didn't have a lot of feedback from everyone to get quite that detailed at that point. But I understand that would definitely be something that, could be emphasized in the legislation.
I think especially given COVID-19 budgetary restraints across the board, we just need to be sensitive about it. So I appreciate if we can add that type of language.
Absolutely.
Okay, great. All right, we'll move on to 17. So just give me a minute here. I was just reading the comments from the prior meeting.
can I just ask Jen, you probably can get your head on the thought. There's a rule that addresses custody evaluators, I thought. I can't remember the rule number, something 205.3.
Yeah, actually, Lori, if you have the draft documents in front of you, it's linked under draft recommendation 19.
Oh, there's a link if I look at it online?
If you just pull up the email we sent you, go to draft.
Yeah, let me do it that. I have it printed out in front of me, so I didn't. Well, I guess my question is, I might not be making my question clear.
I'm sorry.
Isn't there a Maryland rule that says custody evaluators have to do X, Y, Z, And if so, what's that rule number? Ah, here it is. I'm sorry, down here under 19, 9205.3. Okay, sorry. Because I'm wondering what the interplay between 17 and that rule are. And maybe it's down here in recommendation 19 rather than in 17 that there's the interplay.
For both of these, because I was reviewing the rule again, I think, and again, we're all going back to many months ago. The idea is that some of the things provided in the Maryland rule are vague and leading to some undesirable results. If I were jumping to 19 specifically, I was looking at the part where the things that are required in the report include a review of relevant court records or a review of any relevant educational, medical, or legal records pertaining to the child. What is relevant is left completely up to the discretion of the individual custody evaluators. There's no sort of guidance provided on what, and then also the weight of those different documents is not dictated as to what might be more important or what's less. So just an idea that that rule is not wrong, but maybe it's not providing strong enough guidance in a way that we would like for this particular work group's focus, where there are especially allegations of domestic violence or child abuse, especially.
Did the AOSC ever get back to us with how many people that had been waived under this?
I don't believe they did.
Okay.
They didn't think it was many people, but I find it somewhat hard to believe because it's a relatively new rule, I think.
And then in terms of qualifications, it's things like 2 years of practice in social work is what I'm remembering for certain things. But again, it's not like, is it specifically in stuff related to what we're concerned about here? So I think the idea is that we want more specific fleshed out requirements, especially where these cases are concerned, than the Maryland rule currently provides.
Okay, well, why don't we say that? I mean, that's a good point. Let's add that in. Okay, anybody else on that particular recommendation? Okay, draft recommendation 18.
Mr. Secretary,
Yes.
I just want to be clear because we jumped to 17 and down to 19. Do we think we need to either combine or tighten up, or I'm just trying to make clear on what we're doing with 17 and what we're trying to accomplish with 17 and what we're trying to accomplish with 19, and if those should be combined or not. I'm raising it as a question since we kind of hopped right down to the Maryland rule. Jen, do you have any thoughts on that?
I'm not sure which Jen here, but I'll jump in for that.
Or Michael, I just, we started talking about 17, then we went down to 19, and I'm just wondering if we need to look at what we're trying to do with 17 and what we're trying to do with 19.
Sorry, Jen.
I was just going to say, Mr. Secretary, you mentioned the time. I'm not sure what sort of time constraints people have. This might actually be an area where it might be helpful if everyone, I tried to get subgroup C to sort of give some feedback, but didn't get anything initially. Right. So maybe everyone could just sort of look over, as Laura says, what the rule has now, and then what particularly we want to change, just to sort of get these recommendations. You know, they don't have to have every piece of language, but it would be helpful to know exactly what you want in the standardized assessments, and just to sort of flesh this out a little bit more. But it might be kind of hard to do over Zoom on video with everyone trying to frantically read the rules here in the amount of time that we've said we've allotted to it. So this might actually be something worth coming back to, given the importance of it.
I think you're exactly right, Jen. That's a great thing. We'll have time to do that on the 25th. I mean, we've gotten through a good portion of this, I think, pretty well. We have a few things that we've got to go back to, but that's a fundamental thing, as you were just mentioning. So maybe let's look at that and bring that back for discussion. at our final meeting that we have coming up on the 25th. So let's work on that, and get your thoughts together, and also please go ahead and share those ahead of time so that we can have those ideas down and start and have some final discussions and sort that out. Okay. And then so let's go then on 18 and just say, is that something that I guess somebody thought that was a key problem or a key issue on the evaluators. I mean, as is said, as far as general provisions about providing legal advice crosses many other areas. So there must be a reason why someone brought it up in this particular context. Anybody want to speak on that?
My recollection, which could be faulty, was that it was brought up by the protective parent and her specific experience.
Okay.
But maybe I'm wrong about that. So.
Anyone else have thoughts on it? Is it something that we've encountered, or that we all? I mean, yeah, we may have heard about it from one person, but is that a general issue? Go ahead.
I am mistaken.
Jen Young, go ahead.
No, I was interrupting the protective parent. I actually it just clicked in my head, and I was mistaken about that, and I apologize.
That's okay.
Okay, that's what I was going to say. Thanks.
Anyone else on that? Go ahead.
We can just make the licensing board report if they've done anything. Maybe that's an easy way to do it.
Sure. All right, good idea, Michael. Let's do that. Okay, we'll skip over 19 since we've already talked a little bit about bringing that one back. And then the final one is 20. And that talks about record keeping requirements, which I think, again, we've heard some comments about. Thoughts on that?
Mr. Secretary, that might fall into the same category as what we've already sort of suggested that we go and take a, maybe a little more specific look at.
Okay.
Once we decide what we want the custody evaluators to have to actually do in their report that's different from what's required now, that might organically sort of lead itself to some uniform record keeping recommendations.
Right.
If I could add, again, kind of coming in on this, maybe if we, like when I looked at that recommendation, my first question was, what is currently required? And before we talk about uniform record keeping requirements, I was just trying to better understand what was currently required. And is that something that can easily be pulled out for us to look at, or do we need to go back to that Maryland rule, or is as far as trying to flush out that recommendation? 19 and 17, are those all kind of tied to reviewing the Maryland Rule 9-205.3 to better understand the recommendations we're making for 17, 19, and 20? Question mark.
I think so. Senator Carrizo, I copied those exactly from subgroup C recommendations that were presented. No one gave me anything further to go on. So I'm not aware of what discussions you had. I know you led that subgroup. What type of discussions you had during those meetings when you guys put together those recommendations, but I certainly think that would be helpful.
I think there was in our group, obviously, general agreement on that statewide uniform record keeping requirements. I think because I think it's been a little while since April, and now here we are in July, probably a refresher before our next meeting just to understand what's currently required so we know what our new requirements might be.
Okay.
And if anybody on the subgroup wants to expand on that, here's your chance.
Right. Speak now or forever hold. Well, okay. I think we should probably at this point wrap up what we've done. Again, great thanks to the support that we've been provided, and I know that Jen and Heather and Jen all have really worked hard on all this, and they've done a superb job in trying to pull all this together, because there's a lot that they've done, and I just would again encourage you all to do your homework now on the other points that we've covered today. And Jen, I think if you'll just summarize that in an email to all of us
Sure.
as to what the remaining tasks that we have to get done between now and our next meeting.
Sure.
If you could do that, please. And once again, I just want to say thank you very much to each and every one of you. You all bring marvelous insights and experience and brain power to this effort, and it really is greatly appreciated, I know, by all of us. So thank each and every one of you for that effort. It's for the right causes. So thanks again, everybody.
Thank you.
Okay, we'll catch up with you soon.
Thank
Thanks
you.
so much.
Bye-bye.
Bye-bye.
Thank you very much.